Consider the following scenario. You want to purchase a house. One small problem, it's bright pink. So, you include in the purchase agreement a requirement that the seller paint the house. The seller fails to paint, but you close anyway and accept a deed. Can you sue the seller to enforce that prior agreement? A Utah court considered this question in Panos versus Olsen. Patrick Panos planned to sell a vacant lot next door to his house to Olsen and Associates Construction. However, Panos loved the view from his house and wanted to preserve it. So he ordered a survey to determine the greatest height at which a home could be built before his view was obstructed. Measuring from a brass marker on the adjacent street, the survey determined that 32 feet was the proper height limit. Both the purchase contract and the deed contained a prohibition against constructing any building on the lot higher than 32 feet, as measured from the existing adjacent street. Neither document mentioned the brass marker or any other specific point for measuring the height restriction. After closing, Olsen built a house on the lot. Panos complained that it violated the height restriction. Panos' survey indicated that the house was approximately 35 feet above the brass marker, a violation of about 3 feet. On the other hand, Olsen's survey, measured from a gutter further up the street, indicated that the house complied with the height restriction. Panos sued for breach of contract. At trial, the parties disputed whether Olsen had seen the original survey or discussed how the height restriction should be measured. Olsen moved for summary judgment, arguing that the merger doctrine applied and that the house complied with the restriction in the deed. Panos asserted that the merger doctrine didn't apply because the deed contained a latent ambiguity and a mutual mistake regarding the specific point from which the height restriction was to be measured. The trial court granted summary judgment for Olsen. Panos appealed to the Utah Court of Appeals.